Hello everyone, this is Associate Vrinda, Legal Associate at NRI Legal Services. Today we are going to discuss regarding the legal framework for joint property ownership in India. Property ownership in India is a dynamic and evolving field with various legal frameworks in place to govern the joint ownership, whether it's for the familial reasons, business ventures or investment purposes. Understanding the legal aspect of joint property ownership is crucial. This video aims to provide an in-depth overview of legal framework for joint property ownership in India. Let's talk about the types of joint property ownership. There are various types of joint property ownership. Firstly, joint tenancy. It can be understood as the kind of ownership of property whereby each co-owner shares their interest in the property. The right of survivorship is crucial in joint tenancy, whereby the joint owner surviving the other gets the share of the joint owner dying first. The co-ownership of property in joint tenancy need not to be shared among the relatives since it could be a stranger as well. Example could be a group of friends owning a land jointly. Joint tenancy grants equal ownership rights to all the co-owners. If one co-owner passes away, their share automatically passes on to the surviving co-owners, avoiding the process of succession. Secondly, it is the tenancy in common. Diverting from the concept of joint tenancy and co-ownership of property, tenancy in common gives undivided interest in the property to everyone. In this type, each co-owner pays a separate consideration for the property based on which the shares in the joint ownership of the property are determined. This share can be transferred or inherited. In the case of demise, the deceased's share is passed on to their heirs. The possession under this kind of tenancy is considered common unless there is an agreement. In joint agreement, one or more tenants may buy other tenants to end the tenancy in common. For instance, if 5 partners buy an office space to carry out their business, the extent of ownership of each partner or co-owner shall depend upon the amount of consideration, unless decided otherwise. In case one of the partners suffers from untimely demise, his or her legal heirs will become the rightful co-owners to the extent of the property held by the deceased partner. Thirdly, tenancy by entirety. This form of ownership is limited to married couples. It grants each spouse an undivided interest in the property. In the event of one spouse's demise, the surviving spouse automatically gains full ownership. If one spouse voluntarily decides to modify the agreement and initiate the divorce proceedings, the joint ownership can be altered. It is pertinent to mention here that the spouses are not allowed to sell, transfer their share held by the tenancy by entirety to a third person. Fourthly, coparcenary. It is a concept exclusive to Hindu religion, whereby after a few generations living jointly an ancestral property, people get a rightful share in the property by birth or even by adoption. Both the sons and daughters are equal shareholders in the ancestral property, being a coparcener. All the coparceners are joint owners with equal shares in the property. Examples include co-owners with grandfather, father, aunt, son, sisters and daughters, all born into a joint Hindu family having an ancestral property. Let's move forward by knowing what are the rights of co-owners of property. As per Section 44 of the Transfer of Property Act 1882, there are 3 rights that a person enjoys being in a co-ownership of property. Firstly, right to possession. Secondly, right to use. Thirdly, right to dispose of share. Let's talk about right to possession. Each co-owner has a right to possess and enjoy the property. However, they must do so in a manner that it does not infringe upon the rights of other co-owners. Co-owners are collectively responsible for the maintenance and repairs of the property. Expenses should be shared proportionally unless otherwise agreed upon. Secondly, it is right to use. If the property generates income such as through rent, each co-owner is entitled to a share in property to the ownership stake. Thirdly, right to dispose of share. Co-owners have the right to sell or transfer their share subject to the consent of other co-owners. However, if the property was purchased with a specific condition, those must be honoured. If the co-owner is enjoying separate possession of a property as specified in an agreement, in that case, he can sell his share to any third party. It may be also noted that one or more of these rights may be restricted by some condition as per the agreement between the joint owners. For example, disposal of joint ownership of property may be subject to the consent of the other owners. However, all these rights are restricted to the share of such co-owner. In most of the cases, unless it is in the case of married couple or so. Let's proceed further by knowing the termination of co-ownership of property. Different owners might want to control their properties in different ways and have different objectives. There are various ways to deal with the issues arising from the joint ownership of property. A joint ownership of property may come to an end through the following pathways. Voluntary partition. If all the partners mutually agree to end the ownership of property without the court's intervention, the co-owner who have joint ownership in the property can execute a deed of partition or a family settlement with the terms as per their mutual understanding. In this manner, the shares can be decided as per the wishes of all. Secondly, termination by the court is also an option if the co-owner are not able to reach a common podium amicably while discussing the partition. In that case, where no partition deed is executed on the basis of common consensus, the co-shares who in property can file a suit or before the appropriate court of law. A tenancy in entirety may come to an end with the divorce or death of one of the spouses. It may also terminate with mutual consent of the husband or wife. Lastly, release or relinquishment deed in case of family members willing to transfer their share of property in the name of another blood relation without seeking any consideration. Dispute resolution. In the event of disagreements among the co-owners, seeking legal intervention becomes necessary. Co-owners who have competing interests or rights on the property might divide the property through a partition suit, which is a legal procedure. In India, there are several different rules and ordinances that must be followed in order to divide the property. The court may order a physical division or a sale of property with the proceeds distributed among the co-owners. Thus, if you are a co-sharer in a property, at first it is advisable to ensure that you have a separate possession of the property and there is no interference on that property. Tax implications. Joint property ownership has implications for taxation. Each co-owner is responsible for their share of property taxes and any income generated from that property is divided to the ownership percentages for tax purposes. Concluding my topic, I would say that navigating joint property ownership in India involves a thorough understanding of the legal framework and careful documentation. Whether it's for the investment purposes or personal use, being well versed in the rights and responsibilities of the co-owners is essential. With the right knowledge and legal guidance, joint property ownership can be mutually beneficial arrangement for all the parties involved. I hope that this video would be beneficial for both Indians as well as NRIs. If you want more information or assistance regarding the joint property ownership, then kindly contact us on query@nrilegalservices.com. Do subscribe our channel for more informational videos and don't forget to like, comment and share this video. Thank you.